Okay, thanks. Can I start by acknowledging the traditional owners and paying my respects to their elders past and present? Can I also acknowledge that there have been quite a few people who have made a contribution to the presentation I'm about to give. I've cut it down significantly, but it certainly wouldn't be here without them. Their names are there. If I've missed anyone out, I apologise sincerely. I'll just let you know who I am. I'm a principal at the Immigration Advice and Rights Centre. I'm also one of the PII co-conveners. And I start also by saying that it's going to be very difficult to follow Nassim's presentation. Firstly, because I don't think I can match his charm and enthusiasm, but I'm also going to be selling you a very different story about legal practice. All right, so what we'll be covering over the next hour and a bit is we'll be looking at insurance, we'll be looking at risk management issues in community legal centres, and we'll be looking at how to go about addressing those issues. Why? Why do we need to know about this? Why do we need to address this issue? Because it's inevitable in day-to-day practice that things will go wrong. Anyone sitting here who's going to say, well, not in my centre, is wrong. Now, I've approached this presentation, and I generally approach my own practice with a view that, and perhaps it's a simplistic view, but it's a view that things go wrong for two reasons. One reason is human error, where there's no systems or processes can prevent it. Things like CCing in everybody as opposed to pressing reply or forward. Just human error, spilling your coffee on your file, or people have bad days, it happens. The second area where, in my view, things go wrong is human error where there are no systems in place to prevent it. Now, hopefully by the end of this presentation, if you adopt the various strategies which we'll talk about and certainly appear in the risk management guide, then you should certainly be able to, not always, but more likely than not, identify the first and prevent the second. There is, of course, a third reason where things go wrong, and we won't really talk about that, but generally sort of rogue lawyers who do things and you don't know about it. But, and the other thing is, also I should say, if you've got any questions or any comments, please stop, raise them. I don't want this to be me having a chat. I think it's most useful if everyone makes a contribution and expresses their own opinions and experiences. So yeah, I think I mentioned that. All right. So what is insurance? Professional indemnity insurance is basically there to cover claims made against the legal centre. Each community legal centre is covered by insurance, which is generally organised by NACLAC. Our current insurance policy is with CGU, and we pay a yearly PII cover. What is covered? Essentially, insurance against risks for providing incorrect advice or missing critical dates. The most common claims, or I should say it's not just claims, but notifications we see, arise out of being out of time, basically missing deadlines, or the other one there, of course, is being out of time to commence or avoid legal actions, conflicts of interest, incorrect advice or failure to advise of an issue, general complaints, lost, damaged files, and unintentional defamation. So you can't go rogue and expect to be covered. What is not covered? Things that aren't covered include known claims, existing claims which were there before you got your insurance, issues arising out of foreign jurisdictions, such as somebody taking you to some foreign court, issues arising out of the normal course of professional service, loss or profit, refund of fees, and punitive damages. Now, issues do arise, and when they do arise, there is a requirement that you notify a claim or a loss. How do you know if an issue needs to be notified? Well, in terms of a claim, any originating process or any written or verbal demand claiming compensation. But there's a further requirement, and that is there's also a requirement to notify to notify the facts or circumstances that might give rise to a claim. So just because something hasn't come up, as in they haven't started proceedings, doesn't mean that you don't notify. Does it matter if the client knows about it or not? Anyone?
No.
Doesn't matter. As soon as you find out there's an issue, you need to notify. It is very important to have a chat to a PII convener. In New South Wales at the moment there's 3 of us. There's Annette at Marrickville, Hilary at Inner City and myself. If we are not available, then you can pick up the phone and call any of the PII people across the country. We certainly take calls from interstate. Chances are you'll be able to track one of us down, but just in case. Why speak to a PII person apart from the fact that it's a requirement? It's because you'll be speaking to somebody who's not emotionally involved in what's just happened. And a lot of the times they can provide if you like, almost a counselling type sessions where they can say, look, you know what, it's not as bad as you think, this is what you need to do. If in doubt, always notify as opposed to not. But that again would be something you can discuss with your PII, because sometimes if you know, for example, what you might be facing is actually lower than the excess with the insurance, then you might decide that you just don't want to deal with it through the insurer. There is a requirement not to make admissions of liability without the express permission of the insurer. Now, I'll come to this a little bit later on, but this is something which I must say I personally struggle with a little bit, because yes, you have an obligation to the insurer, but you also have an obligation to the client, particularly when things go wrong. So it's often really important to have a chat to somebody and try to figure out the best strategy for complying with the insurer, but also making sure that your client's, or your client or your former client isn't being compromised either. Any questions about that? No.
What's the excess again?
I think it's 10 grand. 10 grand. And some of it's covered, a great proportion of it's covered by NACLAC, I think. 7.5. Now, to give you an idea of the sorts of, this is just, I should say, this is just notifications, and we get, reports about all the notifications and claims, and occasionally from time to time notifications come up, but a notification and a claim are very different. So while we might get, let's just say, 4 notifications a month, it's very rare to actually see one of those sort of lead to a claim. From a percent, and I honestly don't know how old this chart is, but I assume the statistics are still the same. But a lot of it tends to be missed deadlines, negligent advice, as you can see there. All right. Now we're going to look at the issue of risk management. Does anybody want to have a guess at what is risk management? What is it? What does it actually mean? Anybody?
Knowing how to get around any sort of potential risk, making sure that you avoid it.
Yeah. Anyone else? Yeah.
Probably saying the same thing, but identifying and managing risks.
Yeah, I think that's probably a really good, concise way of putting it. There is, I suppose, a definition which I'm happy to read to you, but it's no more than what you've said in a... risk management is the process of thinking systematically about all possible risks, problems or disasters that could happen as a result of a particular activity, and setting up procedures that will avoid the risk, minimise its impact or cope with its impact. Risk management should be part of the culture of the organisation. Okay, and why should CLCs manage risk? Why do we need to do it?
Protect our clients.
Protect your clients. And that's actually good, because it's really good to hear that, because a lot of people, I assume, were going to say to protect you from getting sued. or and it's there to protect you as an individual. It's there to protect your centre. It's there to protect the centre's reputation, but it's just as much there to protect your client. And I was actually going to mention this despite what was said at the previous session, but it's very easy to feel comfortable about risk management knowing that chances are your client probably doesn't have the means or the capacity to take you on. Don't be that person. Why we need risk management is to protect the clients who could be damaged by our operations, to protect ourselves as individuals and organisations, and to protect the reputation of the centre, including stakeholders and partners such as funding bodies and supporters. It's also worth remembering that the insurer expects you to be able to do this. If you don't have sufficient risk management protocols in place, then the insurer may decide they're not going to help you. This will be a quick one. Just again as a reminder, as lawyers, you still have to comply with the various rules, regulations, and the laws, rules and regulations with the Law Society. There is the Risk Management Guide, which I brought a copy of. I'll refer to it a little bit later on. And also, in terms of the standards and NACLAC accreditation, Laurel can sort of talk to you about that, I'm sure, at some point. What is the Risk Management Guide? Mine doesn't look like that, mine looks like this. But there would most certainly be one, at least one, in your centre. How do I know that? Because your cross-check would tell me that. Does everyone have one in their centre? Does anyone not know where it is? Has everybody read it? Okay. Read the guide. It's a requirement for everyone to read Chapter 2, but it's actually incredibly useful to read it from back to front. It has a lot of very skillful, intelligent people have put a lot of time and their skills into it, and it's actually I found it probably the most useful thing that I've had access to, and I assume a lot of people would agree with that. I'm just going to repeat this because it's important. If you've got any questions about it, if you disagree with anything in the guide, have a chat to one of the conveners. Okay. So what does the Risk Management Guide actually tell us? Well, it deals with issues of supervision, monitoring workloads, dealing with monies, giving legal advice, open files, file closures, file reviews, and volunteers. And this is going to be a bit of a group exercise. I will be turning to you. But who retains responsibility for supervision? Yeah. So the principal solicitor, a nominated person, responsible person. Anybody else? I suppose anybody that's, as you say, anybody that's delegated that task. Who's responsible for monitoring workloads? Anybody else?
Individual solicitors as well.
Yeah. And I think that's really important because I think as there are people here who aren't principal solicitors obviously, but if you yourself are struggling with your workload, don't assume that the principal knows. If you're missing things, if you've got too much, or if you've got what is normally okay, but life's just difficult at that moment, then while there's no expectation for you to supervise yourself, I think it is incredibly useful for you to be alert to those issues and let your supervisor know.
I mean, I also argue that probably managers and governing boards too, in terms from a work health and safety point of view.
Absolutely. Yep. I absolutely agree with that. Boards and the responsible person must ensure centres are mindful of their limits and resource constraints and don't take on more work than staff can handle. Dealing with monies will... What is a reasonable workload? What's capacity? What does capacity mean to people? I can tell you how I approach it, but what does capacity mean to you?
To be able to do the work that you're actually given within the time that you should have it done by.
Yeah.
You try to ensure that there is a little bit of slack in your work so that you can deal with contingencies.
Yeah. The terminology I use is work that you can safely and happily do in your allocated hours for the week, whether you're part-time or full-time. And I absolutely agree. The reality is that you will estimate something's going to take you 2 hours. It never does. It never does. And I suppose the other thing to be mindful of when you're talking about capacity and workloads is that, my view, each individual's capacity is different, and it is, I think, problematic to set some standard. Different people work at different paces. Different people, depending on their experience, will be able to cope with certain things that others may not. It doesn't work, in my view, to have a set standard. I think it's a good idea to have a starting block, if you like, but you must be flexible to go above and below it. And the sensitivity is trying to make sure that nobody, the culture still doesn't change in terms of, well, I'm working more than the other person. Yeah.
I also think it's also about balance in terms of having enough time, not just for casework and legal clients, but also having a balance so you can access supervision, so you can access professional development, and actually the kind of core legal work is really only one part of having, reasonable workload.
Absolutely. Did everyone hear that? So the capacity in terms of what your work involves, you've also got to be open to the idea that a lot of your time is going to go towards either being supervised or supervising. Those random calls that come in. There's all this other work which often we don't take into account. It's quite important to have guidelines about the types of work you do and you don't do. Why? I mean, we do it. It's easy. We do immigration law. We don't do other things. But in terms of generalist centres, do other generalist centres have a guide of what they do and they don't do? Why? Why do you have it?
Depends upon your expertise for one, and also as far as ethics goes, to what you can and can't do.
Exactly. Yeah. And the other reason is, I suppose, going along that is you, as the person who's making decisions about what you're willing to supervise, you want to put limits on it. You don't want the solicitors just to be doing anything that comes their way. Okay. Arguably, one of the most important issues to come out of the risk management guide, in my view, is the duties and obligations that lawyers owe their clients. Now, I suspect there would be, I know there's different views about how to apply these issues. And as I say, I probably take a more conservative view on this issue than Nassim, maybe. But it's important to recognise that solicitors, you have a duty of confidentiality, a duty to act honestly and fairly in your client's best interest, and a duty of loyalty under a fiduciary duty. A conflict of interest is better described as a conflict of duties where there is a clash or tension between two duties which would lead to a breach of confidentiality and a breach of duty to disclose information material to a client's case. And I suppose this probably arises from what Nassim sort of discussed earlier. As a general rule, a conflict of interest at any time during a matter means you can no longer act for either party. That's the general starting point, but is that always the case? Well, Nassim's experience is no. Does anyone hold a different view? Or does anyone want to share their own experience? Yeah.
Well, isn't it the case that if a conflict of interest does arise, then that is the case, but then the real kind of pointed question is whether there is in fact an actual conflict, and what may appear a conflict in Celsius or on just looking at the document may not in reality represent a conflict of interest.
Is it important to avoid a perception of a conflict
Yeah, that's really
as opposed to an actual conflict?
Yeah, yes.
And I suppose maybe that's where you have people who take a very black and white approach and people who take perhaps more of a different approach. I've worked in a centre, and I won't say where, under a principal who we had a client who were acting for a mother and daughter, and the daughter, well, we're acting for mum, and the daughter, who was I think 16 at the time, came to us and disclosed that she was being abused by dad, but told us that she didn't want us to disclose this to mum. Could we act? Could we continue to act for one or both? Any views? The principal decided to continue to act. But I suspect I would have really struggled with that.
What was the nature of acting for the mother? What was the matter?
It was in an immigration-related matter, but Dad was already here as well. Is that what you?
Yeah.
It was an immigration matter, but yeah.
So was there confidential information on either side that would assist the other person's legal matter?
Yes, because it would have, yes. The child, based on, for example, the abuse, could have advanced claims on their own behalf.
So the two separate issues. They'd be two issues, wouldn't it? Because you'd have one regarding the mother and the other one would be...
They were in the same
child.
application, though. You see, they were in the same application.
But you're still able to advise the child that if they want to increase their immigration prospects alone, that they have a stronger case if they do X, Y and Z, and then it's up to them to instruct you as to whether to do that or not.
It is, but I suppose the difficulty arises when the child says, "Can't tell mum."
But why does acting for mum means you have an obligation to tell mum that information?
Perhaps an approach would be as a to start off with. Does a lawyer not have an obligation to be completely open with their client about what they know?
I don't think so, only if it's in their best interest. But yeah,
It's relevant.
obviously raises lots of potential.
I mean, the child was under the age of 18, so who was giving the instructions and the child was, who was the tutor or who was the...
The child turns up to the office on their own. Randomly turns up to the office on their own.
It's the issue that the child's information that she's given can advance mum's claim because it will assist her immigration application because of dad.
But let me also explain why this, in my view, became problematic. It became problematic because at that point, the lawyer who had carriage of the matter decided to say to mum, because the decision was to continue to act. The lawyer then said to mum, "It's in your interest to actually have separate interviews." It didn't explain to mum why.
The other issue, I suppose, is whether it's, I mean, obviously you can't run a matter that, I'm not an immigration lawyer, but you obviously can't put a case forward that you know is not correct, it's misleading, and that's, I mean, so I don't know
Yes,
if
yeah.
that's an issue.
Immigration lawyers are still officers of the court. You can't make a submission, you know, that's not true.
Yeah, so if that became a particular issue where you were making submissions about, say, the character of Dad that you knew was not correct, then that would be a real bind.
Yeah.
Then there's the issue of the mother becomes hostile, she was to find out, and
Absolutely.
it's going to the daughter,
Absolutely.
and you can't work with the wife.
Yep. And the other thing is also bear in mind that mum can obtain those documents under freedom of information. And as the child is under 18 and she's a guardian, she can actually get that information. It also becomes, I tell you where it also becomes tricky. It becomes tricky because at some point the department also has to make, or even the tribunal has to make a decision which comes with a decision record. You know, do you say to the tribunal, can you listen to it but don't put in a decision? You can't. But yeah, at the back.
I was going to say, did you also act to break the child client's confidentiality by making a report to Dom?
I wasn't the lawyer.
Right. Because obviously that, you know, you've got an obligation there to actually do something else with that information rather than leave the person, that child at risk.
Yeah, I don't know. I can't answer that. I don't know what else happened on the farm. But I just remember this was an issue that was raised in terms of whether or not. But what if it's, for example, what if you're running a partner visa case, and well, this is probably more relevant to the migration. But like issues where it's a domestic violence case where you previously advised the partner on a traffic matter. Do you cut it off or do you continue to act? Any different? The consensus is continue to act. Any different views? It depends. It depends. It depends. And I think really it depends on what you know.
And very much the perception, if you have a vulnerable client, it's a
Absolutely.
victim of domestic violence. Your client's out, your advisor acted especially if she's most frightened.
Yeah. And who makes the decision? I mean, what do you do when a conflict issue arises?
Discuss with the principal solicitor.
Yeah.
Have that discussion and just work it out.
Yeah. A difficulty that's come up for me in recent months is we've had clients who have contacted us, and when they've identified the other party, we can see that at some point we gave the other party advice. So I'm talking about maybe 10 years ago. The difficulty is I don't have access to the advice. I don't know where it is. I can't find it. In those circumstances, what do you do?
Do you know it exists in your centre somewhere? Or it's been destroyed? You know it's been destroyed?
I can't find it. I can't find it. So, I mean,
Any knowledge that there could be disclosure and you don't have.
And the public perception is after 7 years the records are destroyed, so there's no issue with the public seeing it as a potential conflict.
what about the client?
The client,
Yeah.
that's up.
Does a client not have an
Do you have access to the
expectation?
former client?
Sorry?
Do you have access to that former client from 10 years ago?
No, but
They
no.
informed that after 7 years that the files gets destroyed.
What if it's just an advice client? Does it make a difference?
Yeah, it can, so it's these are all the things you need to weigh up.
Yeah, it is. You've got to weigh them up. I don't think there's a simple answer. As I say, I personally take perhaps a more conservative view because I suppose I also put a lot of weight on the perception of conflict, and I also put a weight on the expectation of previous clients, the expectation of a client on their lawyer not to act for somebody who is another party. Yeah.
I have a little bit of an issue with that. Like, how can you, I come in as a client for a traffic matter, and then you end up assisting 5 years
Yeah, and that's a matter for you. As I said, I mean, there's no sort of blanket rule on it. But also the other thing I'll say is I think different areas are. So for example, for us, it probably would be an issue because we only do one area of law. Yeah.
The other thing about conflict checking is not just checking. This is an issue for us. It's not maybe getting to that. It's not just about clients. It's about people on your board, employees, people who you perhaps would work with on a very regular basis.
Absolutely.
Yeah.
So I mean, well, the next point I suppose. Let me just see if it's this one. Sort of on point. All project services of the CLC that form part of the practice, clients of a project. It would also include sort of associates, board members. Must all be included in a conflict checking regime unless there is an approved information barrier in place. We don't have an information barrier in place, and I honestly don't know how well they work. Does anyone want to comment on that?
I'm from Northern Rivers, and we've got an information barrier around the DBCAS team. They're in Siberia, so not in the main office. They've got their own building, and they've grown exponentially, so they need their own space. Separate databases, separate workers. The policies are overarching in the same. Their IT system in terms of their client files are held separately. So the only interaction is they've got their own nominated person, so I'm not looking at their own files. So the only real crossover that could be is through client complaint. That would get escalated up through the centre manager and then potentially the board, and that's where the breaches could occur for us. But otherwise, they're totally separate in their own tight lockbox.
Yeah. Okay. Well, let me just go back. I think perhaps the next slide's been answered, but why is it important to do conflict checks? And I suspect we've already answered it, but are there maybe 3 or 4 main reasons why it's really important to do conflict checks? Okay. Because you've got a duty to do it. It's to protect the interests of the client. It's a risk management tool to protect the legal service and to ensure compliance with the risk management guide. It's really important that when a conflict does arise, again, this is maybe more of a community legal centre focus, but when a conflict does arise, what do you actually do to the client? Do you just sort of say, okay, look, conflicts come up, can't help you, I'm out? Yeah.
You try to refer them to another service.
You try to refer them on, which can be really tricky to refer a client on without disclosing the conflict and probably more importantly, the nature of the conflict. Does anyone have a strategy for that? Yeah.
We just inform clients that we can't assist them, but they would be well assisted if they went to marital community legal centre, as an example.
Do they ask why? I mean, I know they do. Our clients ask why, and it's often very difficult to try to explain to them.
We don't try to explain to them.
Is that a policy of the centre? Yeah. Does anyone else have a better approach?
Legal Aid had a policy a couple of years ago.
Sorry.
We also do something similar where we don't tell them that we have a conflict, or we simply say we can't assist you. But if you ring, for example, our neighbour is Macarthur Legal Centre, you ring Macarthur Legal Centre, tell them that you called us and we can't help you. And so our colleagues at Macarthur know that that's what we're saying to them, is that we have a conflict without actually telling the client that we have a conflict.
Yeah.
I know some centres that say, oh, for professional reasons we can't, act for you or we can't assist. Clients as well, what does that mean? So, well, I can't tell you what that means, but call the law society, they'll be able to do it. Law society says, oh, they've got a conflict of interest. So it's neither here nor there, in my opinion. They're going to find out what it means, so we don't need to shroud what that means.
We're a bit more explicit in our
Yeah.
script for our students.
Yeah, but I mean, my view is I also think it's important not to lie to people. Like, you know, do you just say, look, we can't help you because we don't have capacity? Well, you do have capacity because, you know, my neighbour saw you yesterday and I've got a friend who called you 15 minutes ago. I also think it's important not to get caught out in a lie.
But quite often, we've had this discussion in the past, but I say it's a conflict issue, and I give examples of a variety of different conflicts, and it could be any one of those. So, and that way they don't know whether it's the other party, it's them, or whatever, it's just, so they understand the professional requirement, and they usually okay with it. If we don't tell them that, then they get annoyed as to why can't you help? And that makes it worse for them, they get really aggravated.
Yeah. Is anyone here from a centre that doesn't have any other centres very close by? I.e.
Define close.
close enough. You would be there.
Yeah.
How do you deal with it?
Well, having a good relationship with another CLC, I've done swaps with Broken Hill and said, okay, can you do this by phone?
Yeah.
If it's not appropriate by phone, then we look a little bit closer. But most of the time it's been manageable through phone.
Yeah. But also importantly, it's important that when a conflict does arise, you've got to be able to show that you've got appropriate procedures in place to deal with it in case a claim or a notification does come up.
The tricky ones, I think, I'd say
Yeah.
is when you're already acting for a client, when any other parties, there's no conflict at all, and so you're helping them with stuff, and they come along with a new matter,
Yes.
and they say to you, oh, but I want you actually to help me with this now, and you do have a conflict with this. That's very difficult to manage in terms of them saying, well, why can't you help me with this?
Yes.
Why can't you help me with why? Because you've obviously got quite a strong relationship with that client, that particular client. So, and I'm grappling with this issue at the moment, and so it's the issue is how do you manage that so that you can still maintain the confidence of that client to say, well, I'm on your side for this, but I can't help you with why. Because what I'm fearful is that if they say, well, why you can't do it and why, and they start questioning you in terms of your confidentiality and your commitment to the other issue.
You've got competing issues there.
Yeah.
Have you formed a view?
I've dealt with it in a way.
You're not willing to share? No fair.
But but I have dealt with it in a way. But there was another sort of and I've dressed it up as. And I won't say dressed it up. It's not. It's a real issue. I've said that there's other which I can declare. Where I can say, look, X person was on our board. I'm not breaching anyone's confidentiality by doing that. Is connected to the other person and say, for reasons we can't get involved in this matter. It's about community perception. It's about, and so I've been able to sort of use another relevant reason to say we can't help, but without saying, without declaring that in fact I've actually given advice to the other person as well. Not me personally, sorry, the centre.
Yeah.
It's not satisfactory. It's not
really difficult.
But it is a trick.
You're in a really difficult position.
Yeah, and this is a very sensitive client.
And the other thing you've got, as you say, you've got to factor in is how appropriate is it to simply stop acting for a client who's vulnerable and who's been with you for years. Yeah.
I know that you made a comment about how important it is to be honest to someone who rings for advice, but I think my difficulty with that is we give advice to victims of domestic violence. We also have a WDV CAS service, and sometimes those clients may not have left their relationship, they may have simply sought advice. So my difficulty with saying to someone who rings, for example, the other party, to say, oh, we have a conflict, we provide your partner with advice, is would potentially put our clients at risk of being harmed if their partners finds out that they have sought advice. And that's why we are very vague when it comes to telling them why we can't assist them. So we may say, you know, ring MacArthur, tell them you rang us, we can't assist you. Or sometimes we might offer to make a warm referral, so I'm saying we can't.
But you're not
help you,
lying in
there's
any of
no-
those circumstances.
What is it?
But you're still being very quite honest in doing both those things.
Yes, but we don't go out and say we have a conflict of interest, because then that invites perhaps potential further
Yeah.
questions about
That scenario,
what's the
we wouldn't say.
conflict of interest.
Yeah, I absolutely agree with you. I think perhaps the point I was trying to make was don't be dishonest in terms of saying if someone calls you up, if you've got a conflict, don't say we've got, you know, I mean, I think the capacities is just one that came to mind, but ideally just say, look, there's an issue we can't help you with, why, you know, I mean, my preference is to say, look, if there are issues I can't sort of talk to you about, but there are other centres around the state or the country that would be willing to help. But I understand what you're saying. You've got to be very, and that's really where the conflict issue really arises, because you can't put your own client at risk.
And breach confidentiality.
And breach confidentiality. Yeah.
Dealt with that.
All right. A group exercise, which you don't have to get into groups for, just yell out. Anyone want to throw out some ideas about what are the PII requirements for giving advice? What do you need to know before you give a client advice? What do you need to know about them? You need to know their name. Let's start at the basics. Why do you need to know their name? Yeah. It's important not only to check the other party's name, but your own client's name. And
Sometimes other previous names as well, a list of previous names.
yeah, and I think the difficulty is you may not know those names until you talk to them. And the other difficulty is a lot of the times other names come up while you're already 3/4 of the way into the advice. What else do you need to know? What else should you know?
The other party.
The other party. Telephone number? Would you want to know, why would you want to know their telephone number? I suppose from a principal solicitor's point of view.
So you can collect the advice.
So you can call them back. Not everyone has a telephone number, not everyone has an address. That's the reality. Email? Whatever you can. Do you deny service to a person who doesn't have an email, a telephone number, or an address? That was unanimous. Anyone feel uncomfortable about giving advice to somebody who doesn't have any of those?
Yes.
I think technically you should tell them that if the advice is subsequently determined to be incorrect, we will be unable to contact you. Are you happy to proceed?
Absolutely, absolutely. The process, or the system I have is you advise them of that, but you also advise them to get a second opinion. And sometimes it has to be, unfortunately, from a commercial firm, but advise them to get a second opinion regardless of whatever I've said.
Or you're limited, well, I suppose that's the final term, information advice, but if you say, look, I'm going to just give you some very general information about process, I'm not going to pay any particular matter.
Yeah. Yep.
And clearly document exactly what you told them. So if
Yeah. Because
Charles calls back again,
if they rely on it. But the difficulty with denying service across the board to people who don't have a telephone number, an address, and an email is you're denying access to possibly the most vulnerable people in the community.
Often I ask clients if they've got family members that they can see on their behalf, and there's always a family member.
Yeah, I've done one other thing.
I also get the approval to send it,
Sure.
and to tell them if they become estranged, to let me know not to send it there.
Yeah. The other thing I've done on one occasion, and this was with a homeless client, is I went through those steps of saying, look, there's a problem with me. In case this advice is wrong, I won't be able to get back to you. Get a second opinion, and referred them to legal aid. And I said, but if you could do me a favour, if you could come back in a couple of days, say come back on Wednesday, and I'm going to have a chat about this. I'm going to show this to my principal, and if they're still happy with it, or if there needs to be any changes, then we'll have a chat again on Wednesday. That probably made me sleep a little bit easier about it. but everyone's got their own approach. You'd want to know that you would want to see some indication that a conflict check has been done. You would want to see the instructions, the advice. You would want to see that whoever's giving the advice has turned their mind to any issues of time limits. Now, there will be time when there's no issues of time limits whatsoever. I insist on everyone at our centre writing in their advice, no time limit. Why would you do that?
Shows that you've turned your mind to it.
I think that's the most important thing for me. I just want to make sure, even if they get it wrong, I want to make sure that people have turned their mind to whether or not there's a time limit. And we've got some really nasty time limits in immigration law. We've got 48-hour time limits without the possibility of an extension. I want to make sure everyone has turned their mind to it. You would want to see, obviously, the date, the name, the signature of the person giving the advice. A tricky one, and I also think this could be quite contentious as well. What about giving advice to third parties? On a daily basis, we would have 2 or 3 people call us who say, my partner's in jail, they're about to be deported, help me.
To deal with those calls.
Yeah, what do you do? Can you give advice to a third party? As a starting point, let's say no. How can you go about giving advice to a third party?
Legal information and referrals for service which would actually provide advice to the person in prison?
I think the difficulty is the person who's calling you is probably calling you because the person in prison either has difficulty contacting or making phone calls, or it may not necessarily be open to them to simply, call you during telephone advice hours.
Yeah. What services are doing an outreach to that prison? I mean, if we're giving advice to somebody who's not the client, you're not going to be able to get the right instructions anyway. I just don't know that we're going to make any progress.
Yeah. Yeah.
Can you convert it to advice to the caller so that the question becomes, my partner's in jail, they're going to be deported, what can I do to help them?
I've never done that, but that's very creative. The difficulty, I think the difficulty is, and I think the point that was made back there is really, I think to my view, quite valid. Their instructions would be incomplete.
And the advice received may be passed on incorrectly.
Yeah. What we used to do is we've got information sheets which are available, well, down at the moment, but they certainly were always open to anybody who wanted to access them. They're on our website, and nothing stops an individual from downloading that and reading it. But actually giving this, when could you give advice to the third party?
Express authority of the actual.
Yeah, at the back.
We do a clinic at a mental health unit, and often it's the social worker ringing on behalf of the client, and the client doesn't have full capacity
Yes.
to give instructions, and we do a process where we determine that the social worker is ringing in a professional capacity with the client's interests. There's no competing interest between the social worker and the client, and then we'll give some limited advice to the social worker to assist the client with their civil.
And then who becomes who's the client you're advising?
It's the patient who's the client, but we make a note that the legal advice was given to a third party because we ascertained there was no way to actually give that advice in a way that was comprehensible to the client.
Yeah. I suppose we take quite a conservative approach to that as well. Our general rule is we don't give advice to third parties. There may be circumstances where, for example, particularly with people people in jail, it's impossible to get them. We just get a consent form. And any advice we give is also, I suppose, problematic because, again, the instructions you're receiving are limited to what the other person knows. So your advice is going to be compromised, but sometimes just the nature of how things work.
That's always
How so?
Well, if you're taking instructions from a third party.
Oh, from a third party, yeah.
But the guide allows it to happen.
Yes, it does.
So it's then it comes back to that individual callback about whether you're comfortable doing it or not in particular circumstances.
What if the client lacks capacity completely? Not the person calling, but the person who actually needs the advice. We also get that.
I want a power of attorney
Or there's no, what if there's no power of attorney?
Or something that,
Or-
you're obviously assessing that there's no capacity, and what are you basing that on, and is that sufficient evidence to
Yeah.
really
So we also get public guardians who call up where the orders are not good enough to receive legal advice, and it can be very frustrating. What do you do?
I have had the situation where I've had someone, a daughter of a parent, calling up saying, I have power of attorney, I want the legal advice on behalf of my parent. And I'm hearing a story which sounds like daughter is trying to stop siblings from having contact with dad. And what does a power of attorney say? It says you can actually manage a person's finances on their instructions. What is this power of attorney? Power of attorney does not say that the person doesn't have capacity.
Yeah.
So, no, I'm not giving you advice.
Can I throw another sort of question? What about where you do have consent to give advice to a third party, but it becomes clear to you that the interests of the person calling are not consistent with the interest of the person who's receiving the advice? I don't have answers, I'm just... yeah.
The game to stop.
Yeah. Yeah. I think, yeah.
Or they initially are all on the same page and they don't
Yeah.
There
Yeah.
at some point.
Right, I think time is getting away from me a little bit. All right. Well, actually, before we go on to those, there's probably additional things with open files, which we might come to a little bit later on. Anyone want to make a comment about closed files? Is there anything particularly that you might want to see on a closed file? Somebody who's not a principal. Yeah.
Data destruction.
Yeah. Which is, do we know what it is?
Generally 7 year except for one of the exceptions.
Yeah. Anyone know what one of the exceptions could be? When would you hold on to a file for more than 7 years? Yep.
capacity?
Will,
Capacity. Who said capacity?
Aboriginal.
Yep. Anyone else? Anything? If there's limitation dates, I've been advised of it. If you don't need to be holding on to anything original, return it. Yes, at the back.
That's kind of problematic for some matters though, because limitation periods for some matters have been removed recently and so it's a difficult consideration for them.
Yeah, in sexual abuse cases, for example, we've started to keep them for ever or for 30 years.
In circumstances where you've told a client that you're going to is that what you mean?
Well, there's a limitation period that changed last year in relation to civil claims and child sexual abuse matters, so there's actually no limitation dates now to bring that type of claim. So
Okay.
even though you've got to, retain the file for 7 years, arguably that it might be somebody's lifetime, you might need to keep it for longer than that because there's no limitation period.
In those cases, would you not simply say that while I've told you I'm going to close it after 7, I won't?
We're struggling with that at the moment because that service is also likely to close. So there's a whole lot of complexity about where those files are retained and is an electronic copy sufficient and what, it's a really complex. And you might have replied to that limitation period when you closed the file 2 years ago, but that's actually changed now. So it's quite complicated.
I don't know if this is good enough, but can you say we're going to keep your file for 7 or more years?
Our closing letter says we may destroy it after 7 years.
But it happens the same kind of thing.
Yeah.
It leaves it open to keep it for longer.
Yeah, and then when I go through the files to close them, on the front I just make a note for myself or whoever is, yeah, maybe not for myself, for the next person. Yeah, I make a note for the next person about anything that's particularly they need to know when it comes to the shredding or the destroying.
Have you actually destroyed any files?
I haven't, no.
Has anyone ever had?
Has anyone ever just, yes, there's a hand at the back.
Going through a process of destroying some of our older files that we're scanning into an electronic archive.
Yeah.
Destroy them. Then we're having solicitors check them to see if they fall within the exceptions, and then those ones are stored in practice.
Oh, so you're
Professional shredding service into it.
So you're still you're putting everything into electronic, and those which are fall in the exceptions, you're keeping the hard copy.
Yeah.
Great. All right. What is a file review system? What is it? Non-principals. What's a file review system? Anyone?
System of reviewing the files.
And how do you do it? How do you do it? How do you do it?
Take the files out, read them.
Yeah, but how do you know it's time to take them out?
Diary.
Diary. Use a diary, a calendar. Centres must have file review systems that use diaries, calendars, or reminder software to ensure that files are regularly reviewed and limitation and critical dates are not missed. What does regularly mean to people?
It depends upon the matter.
It has to depend on the matter. It has to depend on the matter. You know, if we have a file where, you know, hypothetically, if we've got a client who might have an issue with ASIO, for example, and you know that ASIO is not going to look at their case again in a year because they've told you that, is there any point in reviewing it every 2 weeks? Maybe not every 2 weeks, but I think it's probably not good enough to review it every year either. Every month?
No.
Every 3 months?
That's better.
I think, yeah.
Even if it's just dipping it into, oh yeah, that's still there, and dipping in.
Absolutely, absolutely.
Put it back in the filing cabinet.
Quickly to the client, yep, I know you're still there, hi, nothing else is happening.
Yeah, I mean, we'll maybe come to this a little bit later on as well, and I'm mindful of time, but... all right, what about publications, CLEs, law reform, media? Who is responsible for that?
Yes.
What do you need to be on top of? The content?
Don't defame anyone.
All that, leave it alone. All that.
Don't defame anyone intentionally. Yeah. Making sure the content's accurate, I think, is also really important. Is it a good idea to give advice when presenting a CLE? Has anyone ever been tempted to give advice while presenting a CLE? Tempted. Mm-hmm. Yeah. I think the difficulty is a lot of the times people ask, particularly when you're presenting to community groups, they ask you questions which are directly relevant to their personal circumstances. And it can be very difficult to resist.
Or they pretend it's a hypothetical.
I think they only pretend once you tell them you can't. Yes. All right. Very quickly, moving on to the risk management strategies. How to avoid becoming a statistic on that pie chart. I think as a starting point, again, well, let's just say, well, maybe before I go into that, use plain language appropriate to the needs of the client, putting important issues to the client in writing. Flow charts. my view is, I think that as I tried to make the point at the very beginning, you've got to look at this as not being about protecting yourself and your centre only. This is really about the interests of the client. And I really appreciate and enjoy looking through a file where I can see a client has drawn charts and pictures. Because it says to me that when they were interviewing the client, the words didn't make sense, and I appreciate that. And often writing a letter, regardless of how careful you are with the language, is just not going to be enough. Sometimes it may be appropriate. We often think it's appropriate to write letters to clients. Well, I don't know. To write letters to clients when they're a difficult client. It's really important to also write letters to clients when you think that they're particularly vulnerable, or just vulnerable. And if you need to write a letter and attach the drawing you have, so be it. No one's going to be critical of you for that. If you want to colour in it as well, do that as well. You know, the idea is to get the point across to the client so that they can understand it. If words don't do it, sometimes a graph will, sometimes pictures will. So I'm actually sort of very grateful to the staff at IR who do that. Client engagement letters, of course, are really important. And letting the client know exactly where they stand. What are their chances? And I think that's really important as well, because we don't always follow this rule, but as a centre policy, we take on clients who we think have merit. But what does merit mean? Does it mean that there's a very good chance they're going to succeed? It can't be. Because often we take on the clients who actually have a very low prospect of success, which is why they need the representation. So I think it needs to be made clear to them that, look, your chances aren't great, but you need someone in your corner. They need to know where they stand, is I suspect the point I'm making. Please interrupt if you disagree. All right, another incredibly important point, as sort of a few slides ago. You may not think it's important, but you need to establish a diary system. I think this is particularly so for the newer centres that are popping up, who might only have 1 or 2 people in them. That diary system needs to include all those important dates. I won't read them out. But importantly, those dates also need to appear on the file. What are you comparing them to? They need to appear on the file. And it's also incredibly important that whatever system you have is accessible not only to staff, well, not only to the principal, but to staff as well. So everyone needs to know. I mean, it doesn't help me at all if a relevant date is simply put into the individual's own calendar. If you as a principal, and I know this isn't that course, but the principal needs to know what's on today. They need to know what's due today. You know, to have a chat with the solicitor and say, look, is everything okay with this? Have you done it? Develop checklists. Why?
Make sure things are being done that should be done.
And at the very least, if you have a checklist, more likely than not, the individual who's ticking that box is going to turn their mind to the issue. Supervising and mentoring. Everyone will have different strategies. I don't think there's a right or wrong strategy. But the only thing I suppose I can say is that sometimes that strategy needs to change depending on the individual in the centre you're dealing with. And the other thing I suppose I'll say about that is it's going to be impossible to be across every file. It's just not, you're not going to be. You're not going to know the intimate details of every file, which is why it is, for me, very important to speak with my colleagues, your colleagues, on a regular basis about what's going on. Anytime they're working on a particular file, I like to sit down and get an idea about what's going through their mind, what approach are they taking. Yeah.
Sorry to cut you off. I just wanted to know what a critical date is, if it's not a court date or a limitation date.
Anyone want to answer that? What's a critical date?
We might include like when a gift is due,
Right.
like check that, you know, it's come back in time.
Yeah, so for example, for us, the dates we put in, we put, for example, court dates, well, not tribunal limitation dates, but we also put dates when submissions are due, for example, which is important for us because there are provisions that say if you don't respond to a particular letter, we can make a decision automatically on that. So for us, that would be a critical date. All right. Other pointers, don't act outside the CLC practice. Develop a strategy for dealing with social occasions and requests for advice. Does anyone have a strategy?
Don't make it important.
Yeah.
Send them to law access online.
Make an appointment. Yeah. Speak to one of the others.
Yeah.
Say no.
Well, okay.
I had someone related to me who was assisting another person call me up on the phone, and it was a consumer dispute, and then say to the salesperson, "This is my lawyer," and hand the phone. No discussion about what the matter was or anything prior to it, and I said, "Sorry, hand the phone back." And just said, "How dare you?"
Yeah.
Completely up and just hung up.
A lawyer approaches a doctor at a party. This is a joke. and says, "Look, I've had 3 or 4 people approach me already for advice. You're a doctor, you get this all the time. How do you deal with it?" And the doctor says to the lawyer, "Well, I usually send them a bill the next day, and then they never ask me again." The lawyer says, "That's fantastic advice, thank you." And then the lawyer gets a bill the next day as well. All right. Okay. I said before it's impossible to be completely on top of every fact in every file, but something that does help, firstly, is sitting down. I mean, I've said in the past I try to do it weekly, but the reality is it doesn't happen, but I try to do it at least monthly, where I sit down with each individual and take out their case list and ask them to tell me what's going on. Give me an update, and I think it frustrates my colleagues sometimes when they have to remind me which client is what, but I think you just have to I have to deal with that. The other thing I've tried to implement on advice, maybe even from Nassim, was what stops you from having an internal cross-check? What stops you from every, couple of months, getting out the cross-check questionnaire, going into a lawyer's office and pulling out 3 files and saying, does it comply? And trying to get out of that habit of being particularly careful about files around the time of cross-check. Why not be particularly careful about files all the time? The internal cross-checks thing, I think, is a really good idea. You may not have time for it, but... the other thing I suppose I also think is worth saying is things, as I said, things go wrong. Am I being wrapped up? Okay. Things do go wrong from time to time, and that's why there's insurance. It's important to try not to take things too seriously. If you've made a mistake, okay, if you're supervising someone who's made a mistake, they're suffering enough. There's no point in having a go at them. You know what? Nothing's to be gained. You're going to achieve more by sitting together and trying to fix it. And if people are fearful of you, chances are they're not going to tell you when things go wrong.
What's the statistics the last couple of years? Do we have any?
About what, sorry?
Statistics against PI claims.
We do. Have I brought them? No. But we bring them to the PII meetings. So they're not very high. So as I say, I mean, we do get people who notify insurers about, look, you know, it could be a potential issue for us, just letting you know. But in terms of claims, they're very, very small across the country, not even in New South Wales. Do you remember the numbers? But they're not big.
or something.
Yeah, it's not huge.
How do we rate international?
Internationally or nationally?
International.
I have no idea. Well, I'm going to say. And do you know why we rate well? Yeah. All right. Okay. High risk areas and things to avoid. I won't read them out, but I'll say, maybe I'll just point out two things. And the first thing is know your limits. If you're not if you're an immigration lawyer, stick to immigration law. And the other thing, which I'm going to make special mention of because it's burnt me in the past, is trying to maintain appropriate boundaries with clients and not over empathising with them. Firstly, I think it's important to have a very professional relationship with clients, but the risk is being too close to a client affects your judgment. The hard part is how do you stop it? At the end of the day, everyone's human and you're going to sympathise and empathise, and you know you're in trouble when you're having dreams about clients. I used to have this recurring dream where in the middle of the night, I would drive to a detention centre and start digging a hole under the fence. And then those big spotlights would come and the German shepherds would be coming in. Annual cross-checks. They should be occurring mid-year. But their purpose isn't to be critical of a particular centre. That's not the point of it all. It's there to make sure that things are going okay. It is not an opportunity to look at people's files and look at what advice is being given. In fact, that's really quite inappropriate. But it's an opportunity to learn. It's an opportunity to implement. The way I like to think of it is, if I'm doing a cross-check, that's my opportunity to steal other people's good ideas. And that's how you've got to look at it. You're not going to have, everyone's going to have issues with their centre. That's expected. But work with the cross-checkers, work with the PII people to improve things as best as can be. All right. Finally, or maybe, almost finally, what if there is an issue? Speak to a senior lawyer as soon as you can. Speak to one of the 3 PII conveners in New South Wales, who again, Annette from Marrickville, Hillary from Inner City, and myself. Speak to the Law Society. Get an independent opinion. You do, and this is, I suppose, where that conflict for me arises. I'm of the view that you still maintain a duty to your client. You maintain a duty to act in their best interest. And speak to the PII people about how to deal with your insurer in a way that doesn't compromise your requirement not to make admissions, but also doesn't put your client at risk. It's not always simple, so I'm not going to give a simple answer, but open up that discussion. How do I deal with this issue? If I'm not allowed to make admissions, what can I say to my client, what can't I? Again, this might get me into a bit of trouble, but I think your obligation to your client's pretty damn high. But anyway. All right. What not to do? Don't cover up the mistakes. Don't sit on issues. Don't contact the insurer. If you've spoken to the PII people, go to the broker. Don't take a chance that it won't come to anything. Don't try to fix it yourself. don't accidentally lose the file. And the other thing which I think it's human nature is there's often a tendency to try to want to go back and write file notes. Speak to your principal before you do stuff like that. And finally, and I'll reiterate, don't be too hard for yourself. It happens, that's why there's insurance. And if someone makes a mistake, give them a break.
Thanks very much, Ali, and thank you for all the work you do as PII convener in New South Wales, as well as full-time lawyering. You also take that role on, so and this year with 2 other co-conveners as well. So now you all know where Ali is, IARC, and he's the PII convener, so you may hear from people. Could you join me in thanking Ali again? Okay, it's lunchtime. We've got half an hour. We're going to start again at 1:30. Tom, did you want to say something?
I'm just wondering if Ali might be able to tell us if those slides are available.
Ali, the slides?
I can make them available.
We can put them on our website if you like. Do you want to make them available?
The only thing I don't know is when these are slides that were correct. My hesitation is that files that were originally created for the that course they do.
Oh, yeah.
I don't see why they can't.
If Tom wants a copy,
You can have a copy.
he can ask you for a copy.
Yeah, absolutely.
Yeah.